Ladies and gentlemen, for your information, this event is held by a hybrid method. So, we hope that attendees who attend offline are expected to obey health protocols by wearing masks, maintaining physical distance, and washing hands regularly.
Assalamualaikum warahmatullahi wabarakatuh.
Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan.
Good morning, ladies and gentlemen. May peace be upon all of us. First of all, let's thank to the Almighty God for His mercy and blessing, so we can attend the second International Conference on Law and Society, Restorative Justice Theory and Practice in Multicultural Society at the Faculty of Law, University of Jember, Indonesia. Before we start the session, we would like to introduce ourselves. I am Reka Widyanugraha.
And I am Andreas Fleming, will guide you as a master of ceremony today. Without further ado, I'd like to welcome the Honorable Dr. Iwan Taruna MM IPM as the Rector of University of Jember.
The Honorable Professor Dr. Bayudwi Anggono as the Dean Faculty of Law, University of Jember.
The Honorable Professor Dr. Sanitian Burhanuddin SHMM as the Attorney of the Republic of Indonesia.
The Honorable Inyoman Sucitrawan SHMM, MH, as Head of Jember State Prosecutor, Attorney of the Republic Indonesia.
The Honorable Dr. Masahiro Suzuki from Central Queensland University, Australia, and the Honorable Dr. Druk Kwang Lee from Thammasat University, Thailand.
And of course, all audience and all the committee.
Ladies and gentlemen, in this opening ceremony, let us inform you the structure of the current event. First, we have Indonesia's national anthem and the hymn of the University of Jember.
Second, opening prayer.
Third, welcoming remarks from Dean and opening remarks from the Rector.
Fourth, short welcoming dance.
Fifth, keynote speech.
Sixth, awarding souvenirs for speakers.
Seventh, we have solo vocal.
8. Plenary session.
And now, let's start a session by Indonesia's national anthem and the hymn of the University of Jember, Indonesia Raya. Ladies and gentlemen, please stand up. Ladies and gentlemen, please sit down. Next, we have the opening prayer from Mr. Fiskal Maulidian Nugroho SH.MH. To Mr. Fiskal, please have your stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan, and Salam Sehat for all our participants. Dear all participants, allow me to lead the prayer in Islamic way. And for non-Muslim brother and sister, Mr. and Miss in here, I hope that all of you may adjust the prayer based on your beliefs. Bismillahirrahmanirrahim. Oh Allah, our Almighty God, in this beautiful morning, we ask you to brighten up our understanding in learning, expand our knowledge, and keep us away from creation and stupidity. Oh Allah, God of this universe, please give your blessings to all of us and bless our activities. The second international conference on law and society in this morning. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Amin. Amin. Amin ya rabbal alamin. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om, Santi Om, Rahayu, Rahayu, Rahayu.
We would like to say thank you to Mr. Fiskal Maulidian Nugroho SH.MH for the opening prayer.
Ladies and gentlemen, now we will hear some speech. The first speech as a welcoming remarks that will be delivered by Professor Dr. Bayu Dwi Anggono SH.MH as the Dean Faculty of Law, University of Jember. For Professor Dr. Bayu Dwi Anggono, the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam, Om Swastiastu, Namo Buddhaya. The Honorable Professor Dr. Sanitiar Burhanuddin SIMM, Attorney General of the Republic of Indonesia. The Honorable Dr. Iwan Taruna MNIPM, Rector of the University of Jember. The Honorable Inyoman Sucitrawan SIMH, the Head of the Jember Veterinary Office. Our distinguished speaker, Masahiro Suzuki, PhD from Central Queensland University, Australia. Dr. Duk Kwang Lee from the University Faculty of Law, Thammasat University, and the German South Asian Center of Excellence for Public Policy and Good Governance, CPG. Igede Widana Suwarda SIMHUM, PhD from the Faculty of Law, University of Jember, Vice Dean and Lecturer of the Faculty of Law, University of Jember, all participants and committee of this conference. Good morning, selamat pagi, ladies and gentlemen. First of all, I would like to express my appreciation for your presence of this conference. Welcome to our beloved Faculty of Law, University of Jember, one of the best law school in Indonesia. Give applause for that. It's such an honor for us to having the Attorney General of the Republic of Indonesia, Professor Dr. Sanitiar Burhanuddin, as keynote speaker, and both of our speakers from Thammasat and Central Queensland University, Dr. Duk Kwang Lee and Masahiro Suzuki. Once again, welcome to the Faculty of Law, University of Jember, a campus with slogan Ilmu Amal Integritas, or to be translated into English, knowledge, virtue, and integrity. Ladies and gentlemen, as the Dean, please allow me to proudly present the second International Conference on Law and Society, Restorative Justice, Theory and Practice in Multicultural Society, which held and organized by the Faculty of Law University of Jember. For your information, this Law and Society Conference is an annual event. This conference was instead to invite scholars from various academic backgrounds around the globe to discuss and sharing knowledge on contemporary legal discourse. The first event was held in the last November of 2021, entitled Agriculture Law Issue in Multicultural Societies. The topic in this second international conference on law and society will mainly discuss about restorative justice, theory and practice in multicultural society. This topic was deliberately chosen with consideration that restorative justice has become an urgent issue that needs to be carefully examined to find an equilibrium between the interests of the victim of crime on the hand and perpetrator on the other. As you make aware, instead of punishing, restorative justice put more emphasis on the act of reparation. In Indonesia perspective, restorative justice has been introduced in the Janvil system law through a diversion mechanism in 2020. The General Attorney Office of the Republic Indonesia has enacting Prosecutor Regulation Number 15 of 2020 concerning termination of prosecution based on restorative justice. Furthermore, in 2021, we have the State Police of the Republic of Indonesia Regulation Number 8 of 2021 concerning handling of criminal acts based on restorative justice. In that regard, there is a need to take closer look at restorative justice as an alternative settlement of criminal act, mainly on how it shall be implemented in the midst of public demand on retaliation-based settlement. It's never been easy, and this is also part of scholarly text to light up to thoughts in search for a just and fair equilibrium under the banner of restorative justice. I would like to deliver a special gratitude for the General Attorney of the Republic of Indonesia who has willing to be a keynote speaker. In my opinion, Professor Sanitiar Burhanuddin deserves to be named as one important figure in promoting restorative justice in Indonesia for his effort of pioneering the use of restorative justice approach in his office. Give applause to Professor Sanitiar Burhanuddin. My gratitude also for Dr. Duk Wang Lee and Masahiro Suzuki PhD, who came from great distance from Thailand and Australia to be here with us today. I hope our cooperation in next will be more deep. At last, I will give this podium to the Rector of the University of Jember to officially open this international conference. I do hope that this conference will be able to medium for healthy discussion, exchanging ideas and transferring knowledge among speaker and participant. So you need assistance, please do not hesitate to reach our committee. They will be more than happy to help you. I wish you a productive and fruitful discussion. Thank you very much.
Thank you very much to the Honorable Professor Dr. Bayu Dwi Anggono for the welcoming remarks. The next agenda, we have an opening remarks that also open the second International Conference on Law and Society, Restorative Justice Theory and Practice in Multicultural Society, that will be delivered by Dr. Iwan Taruna, IPM, as a rector of the University of Jember. To the Honorable Dr. Iwan Taruna, the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Very good morning. The Honorable Attorney General of the Republic of Indonesia, Professor Dr. Sanitiar Burhanuddin, the Honorable Dean of the Faculty of Law, the University of Jember, Professor Dr. Bayu Anggono, the Honorable Head of District Attorney of Jember, Bapak Inyoman Sucitrawan SH, MH, and Honorable Plenary Speakers, Program Committee, dear ladies and gentlemen. Please allow me to begin my speech by inviting all of you to be grateful to God who blessed us with the health this morning and make us are able to join and participate in the second international conference on law and society 2022. On behalf of the University of Jember, it is my great honor to welcome you to this conference that organized by the Faculty of Law, University of Jember. And Alhamdulillah, the pandemic situation is relatively getting better in Indonesia right now. But however, the program committee of this conference and also possibly the participant seems to have preference to carry out this event via hybrid method. I mean, we are doing this online and offline at the same time. Yeah, it might be due to this, some reasons, such as maybe some delegates still worried to travel due to fluctuation of current pandemic situation among the area in Indonesia. Or maybe there have been a change among the participants who more prefer doing the conference via online because more efficient, more effective, and it happens everywhere right now. I hope it will not totally change as it is because we are human beings, still need to talk each other while tasting a cup of coffee together in the same room, nice room, of course, in the real world or offline. Dear ladies and gentlemen, my deepest gratitude I'd like to deliver the chairman of this conference, the Dean of Faculty of Law, Professor Bayu, due to their valuable work, and of course with the Vice Dean, who has contribution that make today a reality. My special thanks and appreciation to the Attorney General, Professor Burhanuddin, who willing to be a keynote speaker during this conference. Of course, it makes us feeling proud and inspired to have his attention this morning. And also, I would like to extend my warm welcome to all prominent speakers today who will bring a general topic about restorative justice, theory and practice in multicultural society. For that plenary session, we will have Masahiro Suzuki, PhD, from the Central Queensland University of Australia, and then Dr. Duk Kwang Lee. Sorry if I mispronounced it. From Thammasat University, Thailand, and from our university, Mr. Igede Vidyana Suara, PhD. And due to that, our great thanks to all prominent speakers who kindly willing to share their expertise and experiences in this world. Ladies and gentlemen, participants of this conference. This conference, as mentioned by the deans, are aimed to provide a forum for presentation and discussion among scientists, researchers, legal practitioners, and students from several countries who work in the law areas, especially who concerning on criminal law topics. We know that such disciplines and topic that we are talking about today has played an important role in the recent world development. I mean, everyone in the world want to have what we call it, make assure the implementation of justice in society. In view of that, I'm very happy and proud that University of Jember to be a part of this scientific network. I consider this conference as very important which is expected to strengthen further steps of the University of Jember toward a world-class university, as I mentioned regularly in many events. Therefore, I do encourage this kind of activity since it is relevant to the the University of Jember vision and mission. Therefore, we hope that this can also promote extended opportunity, in research collaboration between our lecturers, like researchers in University of Jember, and of course with the researcher from abroad or other institutions. Finally, I hope all scientific papers produced and shared during this conference will inspire us to be more productive and also enable improvement of our work. Well, before I finish my speech, on behalf of University of Jember, once again, I'd like to sincerely apologize should there be inconveniences that occur before, during, or after the event. May Allah subhanahu wa ta'ala bless us with a very good health. Amin ya rabbal alamin. Beginning with the Bismillahirrahmanirrahim, I officially open this conference. I wish you have a good, enjoyable days. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi Santi.
We would like to say thank you to the Honorable Dr. Iwan Taruna, M.Eng IPM, as the opening remarks.
Okay, thank you so much for those speeches. Now, as our warmest greeting, we would like to show you all a welcoming dance by Unit Kegiatan Mahasiswa Jantung Teater, which named Tari Gambyong. To Jantung Theater, please welcome.
would like to say thank you to Jantang Theater for the welcoming dances.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua. Shalom. Om Swastiastu. Namo Buddhaya. Salam kebajikan. Yang saya hormati Rektor Universitas Jember beserta jajaran, Dekan Fakultas Hukum Universitas Jember beserta jajaran, Mr. Masiro Suzuki, PhD, pembicara dari Central Queensland University, Australia, Mr. Dr. Duk Wang Di, pembicara dari Thammasat University, Thailand. IGD Widiana Suwarda, PhD, pembicara dari Universitas Jember, segenap mahasiswa Fakultas Hukum dan Sivitas Akademika Universitas Jember. Hadirin peserta konferensi dan tamu undangan yang berbahagia. Dalam suasana penuh kehangatan dan kebersamaan ini, pertama-tama marilah kita panjatkan puji dan syukur kepada Allah Subhanahu wa Ta'ala, Tuhan Yang Maha Esa, yang senantiasa melimpahkan rahmat, taufik, dan hidayahnya kepada kita sekalian, hingga kita dapat berkesempatan mengikuti kegiatan Konferensi Internasional Hukum dan Masyarakat kedua yang diadakan di Fakultas Hukum Universitas Jember dengan tema Teori Keadilan Restoratif dan Prakteknya dalam Masyarakat yang Majemuk. Kegiatan ini merupakan satu contoh kolaborasi yang baik antara dunia akademik dan dunia praktik dalam skala internasional yang dilaksanakan dalam bentuk konferensi akademi internasional dengan membahas substansi perkembangan hukum dan ilmu hukum yang bersifat komprehensif dan kekinian. Untuk itu, atas nama pribadi sekaligus pimpinan kejaksaan, saya menyampaikan terima kasih kepada Fakultas Hukum Universitas Jember atas kepercayaan yang diberikan pada kami untuk terlibat di dalam kegiatan ini. Dan tidak lupa, kami terus mengingatkan agar dalam pelaksanaan kegiatan ini tetap mematuhi protokol kesehatan karena pandemi COVID-19 yang masih belum berakhir. Kami juga memberikan apresiasi yang setinggi-tingginya kepada pihak penyelenggara yang telah bekerja keras dan cerdas dalam menyelenggarakan kegiatan ini. Semoga Konferensi Internasional Hukum dan Masyarakat ini memberikan suatu andil yang positif di dalam menghadirkan ide-ide dan pemikiran yang kontributif guna pembangunan dan pengembangan hukum yang pada akhirnya dapat mendukung terwujudnya tujuan hukum itu sendiri. Para peserta seminar internasional sekalian, dalam Konstitusi Indonesia menegaskan jati dirinya sebagai negara hukum yang mengedepankan hukum positif, menempatkan hukum sebagai instrumen yang berupa aturan-aturan tertulis yang statis dan kaku. Hal ini tentu berbanding terbalik dengan perkembangan masyarakat yang dinamis dan fleksibel. Di samping hukum tertulis sebagai perwujudan dari aliran yang positifis yang dianut Indonesia, juga berlaku juga yang hidup dan berkembang dengan nilai-nilai keadilan lokal atau sering juga disebut dengan hukum adat. Bahkan Konstitusi Indonesia mengakui berlakunya hukum adat di wilayah hukum Indonesia. Hukum yang baik idealnya memberikan sesuatu yang lebih daripada sekedar prosedur hukum. Di samping harus yang kompeten dan adil, hukum juga harus mampu mengenali keinginan publik yang tergambar di dalam hukum yang hidup di masyarakat serta berorientasi terhadap tercapainya nilai-nilai keadilan, kepastian hukum, dan kemanfaatan hukum. Untuk itu diperlukan hukum yang responsif sebagai sebuah jawaban atas keinginan masyarakat terhadap pemberlakuan hukum yang berlandaskan hukum yang hidup dan berkembang di masyarakat. Untuk menjawab berbagai problematika dan tantangan zaman serta kritik terhadap proses penegakan hukum pidana, sejumlah pakar mulai memformulasikan suatu konsep yang kita kenal dengan keadilan restoratif. Keadilan restoratif merupakan pendekatan penyelesaian perkara tindak pidana dengan melibatkan pelaku, korban, keluarga pelaku, keluarga korban, dan pihak lain yang berkaitan, dan untuk bersama-sama mencari penyelesaian yang adil dengan menekankan pemulihan kembali pada keadaan semula dan bukan sekedar pembalasan terhadap pelaku tindak pidana. Hadirin yang berbahagia, sejak awal perkembangan pelaksanaan sistem peradilan pidana, baik di Indonesia maupun secara global, pemidanaan terhadap para pelaku tindak pidana masih bersifat kontributif yang menitik beratkan pada penghukuman pelaku tindak pidana. Orientasi penghukuman ini bertujuan melakukan pembalasan dan pemenuhan tuntutan kemarahan publik akibat perbuatan pelaku. Namun seiring dengan berjalannya waktu, terjadilah pergeseran paradigma alternatif yang ditawarkan untuk menggantikan keadilan berbasis pembalasan, yaitu gagasan yang menitik beratkan kepentingan solusi untuk memperbaiki keadaan, merekonsiliasi para pihak, dan mengembalikan harmoni pada masyarakat. Namun tetap menuntut pertanggungan jawab pelaku yang kita kenal dengan restorative justice atau keadilan restoratif. Konsep keadilan restoratif pada awalnya dikemukakan oleh Albert Einstein pada tahun 1977 yang menyatakan bahwa keadilan restoratif merupakan suatu prinsip restitusi dengan melibatkan korban dan pelaku dalam proses yang bertujuan mengamankan reparasi bagi korban dan rehabilitasi pelaku. Jika kita menitik beratkan lebih jauh ke belakang, pendekatan keadilan restoratif ternyata telah ada sejak umat manusia itu bermasyarakat dan memulai peradabannya. Beralih ke sejarah Indonesia, konsep keadilan restoratif sudah dikenal sejak zaman Kerajaan Majapahit yang dikodifikasikan dalam KUHP, Kitab Undang-Undang Hukum Pidana Majapahit, Utara, Manawa, Kitab Simbur Cahaya yang berlaku pada Kesultanan Palembang Darussalam, yang sekarang menjadi Kitab Hukum Adat untuk wilayah Sumatera Selatan, dan berbagai hukum adat yang tersebar di seluruh Nusantara. Bapak Ibu hadirin yang saya banggakan, konsep keadilan restoratif terus mengalami perkembangan, termasuk diadopsinya dalam masyarakat internasional, antara lain dalam Deklarasi PBB tentang prinsip-prinsip dasar keadilan untuk korban kejahatan dan penyalahgunaan kekuasaan tahun 1985, Konvensi tentang Hak-Hak Anak tahun 1989, Peraturan Minimum Standar PBB untuk Administrasi Peradilan Anak tahun 1985, dan sebagainya. Konsep keadilan restoratif di Indonesia sendiri baru dijumpai dalam Undang-Undang Nomor 11 tahun 2012 tentang Sistem Peradilan Pidana Anak yang menyebutkan keadilan restoratif adalah penyelesaian perkara tindak pidana dengan melibatkan pelaku, korban, keluarga pelaku, keluarga korban, dan pihak lain yang terkait untuk bersama-sama mencari penyelesaian yang adil dengan menekankan pemulihan kembali pada keadilan semula dan bukan pembalasan. Secara umum, terdapat 5 prinsip keadilan restoratif, yaitu yang pertama, prinsip yang menekankan terhadap bahaya dan konsekuensi yang timbul oleh tindak pidana, baik kepada korban, masyarakat, dan kepada pelakunya. Prinsip kedua adalah yang menekankan kepada perlindungan terhadap tempat dari tindak pidana yang terjadi, seperti terhadap keluarga pelaku dan masyarakat sekitarnya. Yang ketiga adalah prinsip yang menekankan kepada proses kolaboratif yang inklusif. Keempat adalah prinsip pelibatan para pihak tertentu di dalam kasus-kasus tertentu, seperti pelaku, korban, keluarga, dan komunitas masyarakat yang dianggap secara sah dapat terlibat di dalam. Dan kelima adalah prinsip memperbaiki kesalahan. Prinsip-prinsip tersebut harus selalu diaplikasikan sebagai upaya pembangunan hukum nasional, sehingga tujuan luhur dari hukum itu sendiri dapat terwujud, yaitu keadilan, kepastian, dan kemanfaatan hukum. Para peserta konferensi dan hadirin yang berbahagia, kita semua mengetahui bahwa Indonesia pada dasarnya memiliki cukup banyak hukum adat dan kearifan lokal yang dapat menjadi contoh penerapan dari sistem keadilan restoratif. Beberapa masyarakat adat di Indonesia seperti Papua, Bali, Toraja, Minangkabau, dan komunitas tradisional lain yang masih kuat memegang kebudayaannya, apabila terjadi sesuatu dugaan suatu tindak pidana oleh seseorang, seringkali menggunakan penyelesaian sengketa yang di komunitas adat secara internal tanpa melibatkan aparat penegak hukum negara. Penyelesaian hukum yang melalui musyawarah sesuai dengan nilai-nilai bangsa yang sejatinya, yaitu Pancasila. Permusyawarahan dan pemuakatan adalah hasil dari sistem kebudayaan Indonesia. Lebih jauh hal ini ditegaskan pada sila keempat dari Pancasila yang berbunyi, kerakyatan yang dipimpin oleh hikmah kebijaksanaan dalam permusyawaratan perwakilan. Indonesia sebagai salah satu negara yang menganut sistem hukum common law cenderung mengedepankan hukum yang positif dalam bentuk yang tertulis, sehingga hukum dominan bersifat statis, rigid, terhadap perkembangan masyarakat yang dinamis. Hukum yang rigid tersebut cenderung membuat hukumnya menjadi kaku dan mengabaikan hak-hak korban dalam proses pelaksanaannya. Tidak hanya itu, di sisi lain, sistem peradilan pidana dan pemidanaan yang secara umum masih bersifat retributif yang menitik beratkan pada penghukuman pelaku. Sehingga penegakan hukum yang dilakukan kadang menimbulkan kegaduhan di tengah masyarakat. Karena penegakan hukum yang dilakukan cenderung mengabaikan kemanfaatan dan tidak mencerminkan rasa keadilan masyarakat. Para peserta yang berbahagia. Contoh penanganan kasus yang sempat mencederai nilai-nilai dan rasa keadilan masyarakat adalah kasus Nenek Mina dan Kakek Samirin. Masyarakat tidak menghendaki mereka untuk dihukum. Bahkan pada umumnya dalam proses penegakan hukum, beberapa perkara pidana cenderung mengabaikan kepentingan pemulihan hak korban. Sebenarnya kegaduhan penegakan hukum ini pada kasus-kasus Nenek Mina dan Kakek Samirin serta tidak terpenuhinya kepentingan pemulihan korban dalam proses penyelesaian perkara pidana bukanlah kesalahan dari aparat penegak hukum. Karena aparat penegak hukum hanya menjalankan hukum acara pidananya yang berlaku. Hukum acara yang terjebak dalam kekakuan pemenuhan kepastian hukum. Namun lalai dalam mewujudkan keadilan dan kemanfaatan. Ada hukum acara yang baik idealnya dapat memberikan sesuatu yang lebih daripada sekedar kepastian hukum semata. Untuk itu diperlukan hukum yang responsif terhadap perkembangan masyarakat yang dinamis sebagai sebuah model hukum yang mengedepankan nilai-nilai hukum yang hidup dan berkembang di masyarakat. Seiring dengan perjalanan hukum, perjalanan waktu, dalam rangka mengakomodir penggeseran nilai-nilai keadilan, saat ini dalam sistem peradilan pidana di Indonesia, restoratif justice telah berkembang sebagai alternatif penyelesaian perkara yang menitik beratkan pada pentingnya solusi untuk pemulihan keadaan korban. Rekonsiliasi para pihak dan mengembalikan harmoni pada masyarakat dengan tetap menuntut pertanggungjawaban pelaku. Keadilan restoratif menjadi solusi di mana kepentingan korban diutamakan dalam penyelesaian perkara. Dalam hal ini, perbaikan keadaan korban dan pemberian maaf dari korban menjadi faktor penentu penyelesaian perkara. Selain itu, dari sisi lain, tetap memperhatikan kondisi tertentu dari pelaku kejahatan sebagai bahan pertimbangan penyelesaian suatu perkara. Hadirin yang berbahagia, Pasal 38 Undang-Undang Nomor 48 Tahun 2009 tentang kekuasaan kehakiman Yunto Pasal 1 Undang-Undang Nomor 11 Tahun 2001 tentang perubahan atas Undang-Undang Nomor 16 Tahun 2004 tentang Kejaksaan Republik Indonesia mengatur Kejaksaan Republik Indonesia adalah lembaga pemerintah yang menjalankan fungsinya berkaitan dengan kekuasaan kehakiman dalam melaksanakan kekuasaan negara di bidang penuntutan serta kewenangan lain berdasarkan undang-undang. Kejaksaan menduduki posisi sentral dalam suatu sistem peradilan pidana, karena jaksalah yang memiliki tugas, fungsi, dan wewenang pengendalian perkara suatu pidana. Dari tahap awal penyelidikan sampai dengan tahap akhir pelaksanaan eksekusi sebagai satu kesatuan proses penuntutan. Ditambah lagi di dalam pasal 139 Kitab Undang-Undang Hukum Acara Pidana mempertegas hanya jaksalah yang berwenang untuk mempertimbangkan suatu perkara dapat dilimpahkan ke pengadilan untuk disidangkan atau tidak. Kewenangan kejaksaan ini berdasarkan ajas monopoli penuntutan atau dominus litis, oportunitas, dan independensi penuntutan. Di samping itu, kejaksaan merupakan satu-satunya instansi pelaksana putusan pidana. Para peserta seminar internasional yang saya banggakan, selain itu, penegakan hukum yang dengan pendekatan restoratif justice yang dilakukan oleh kejaksaan memiliki ciri-ciri khas yang merupakan pengembangan dari konsep RJ itu sendiri dengan tujuan mewadahi nilai-nilai rehabilitasi dan memperbaiki pelaku kejahatan. Pendekatan keadilan restoratif yang dilaksanakan oleh kejaksaan menyeimbangkan antara kepentingan pemulihan dan keadaan korban dan juga memperbaiki diri pelaku yang hasilnya mampu mewujudkan keadilan tetap memperbaiki keadaan masing-masing pihak. Sehingga sejalan dengan rasa keadilan masyarakat dan tidak lagi ditemukannya penegak hukum yang tidak berkemanfaatan dalam mengupayakan pelaksanaan keadilan restoratif, setidaknya kejaksaan telah mengeluarkan beberapa kebijakan antara lain Satu, Peraturan Kejaksaan nomor 15 tahun 2020 tentang penghentian penuntutan berdasarkan keadilan restoratif. Ketentuan ini sebagai bentuk diskresi penuntutan. Ini diharapkan dapat digunakan jaksa untuk melihat dan menyeimbangkan antara aturan yang berlaku dengan ajas kemanfaatan yang hendak dicapai. Pemberlakuan penghentian penuntutan berdasarkan keadilan restoratif sangatlah selektif dengan syarat-syarat antara lain. Pertama, tersangka baru pertama kali melakukan suatu tindak pidana. Yang kedua, tindak pidana yang diancam dengan pidana denda atau diancam dengan pidana penjara tidak lebih dari 5 tahun. Yang ketiga, tindak pidana dilakukan dengan nilai barang bukti atau nilai kerugian yang tidak lebih dari Rp2.500.000. Selanjutnya, sebagai bentuk tindak pidana yang melibatkan unsur-unsur masyarakat dalam setiap upaya perdamaian penyelesaian perkara dengan melibatkan pihak korban, tersangka, tokoh atau perwakilan masyarakat, dan pihak lain, maka dibentuklah wadah Rumah Restoratif Justice atau Rumah RJ. Rumah Restoratif Justice akan berfungsi sebagai wadah untuk menyerap nilai-nilai kearifan lokal serta menghidupkan kembali peran serta tokoh masyarakat, tokoh agama, dan tokoh adat untuk bersama-sama dengan jaksa dalam proses penyelesaian perkara yang berorientasikan pada terwujudnya keadilan substantif. Yang kedua, Pedoman Kejaksaan nomor 1 tahun 2021 tentang akses keadilan bagi perempuan dan anak dalam penanganan perkara pidana. Pedoman ini sebagai panduan bagi jaksa dalam menangani perkara pidana yang melibatkan perempuan dan anak, sekaligus mengoptimalisasi pemenuhan akses keadilan bagi perempuan dan anak yang berhadapan dengan hukum, terlebih lagi sebagai korban tindak pidana. Pedoman ini juga merupakan terobosan kejaksaan dalam menjawab persoalan hukum atas teknis pelaksanaan beberapa peraturan perundang-undangan yang ada seperti hambatan prosedur pembuktian kasus, kerancuan dalam menentukan posisi korban dan pelaku, hambatan koordinasi dengan pihak lain terkait dengan hambatan sumber daya manusia jaksa atau penuntut umum yang belum memiliki perspektif gender dan anak. Yang ketiga adalah Pedoman nomor 18 tahun 2021 tentang penyelesaian penanganan perkara tindak pidana penyalahgunaan narkotika melalui rehabilitasi dengan pendekatan keadilan restoratif sebagai pelaksanaan ajas dominus litis bagi seorang jaksa. Pedoman ini sebagai regulasi pendekatan keadilan restoratif pada penyelesaian perkara penyalahgunaan narkotika dalam upaya mengobati para pencandu dan penyalahgunaan narkotika yang dianggap sebagai korban dari penyalahgunaan narkotika itu sendiri. Para peserta konferensi dan hadirin yang berbahagia. Sebelum mengakhiri pemaparan saya ini, kami berharap bahwa acara seperti ini dapat terus digalakkan sebagai suatu bentuk upaya mewajantahkan tridharma perguruan tinggi untuk terus berperan dan terlibat di dalam pembangunan dan pengembangan hukum di Indonesia dan global. Demikianlah beberapa hal yang dapat saya sampaikan. Semoga Allah Subhanahu wa Ta'ala, Tuhan yang Maha Kuasa, senantiasa membimbing dan melimpahkan karunia-Nya kepada kita dalam menuntut ilmu dan melaksanakan pengabdian bagi masyarakat, bangsa, dan negara. Amin. Wassalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua. Salam. Om Santi 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 Om Namo Buddhaya. Salam kebajikan.
Thank you to the Honorable Professor Dr. Sanitariar Burhanuddin SHMM as the Attorney General of the Republic Indonesia. Next agenda will be awarding souvenirs for speakers. For Mr. Inyoma Sucitrawan SHMH order representing Dr. Masahiro Suzuki, Dr. Duk Kwang Lee, and Professor Dr. Bayu Dwi Anggono, please have a place in front of the place that will be followed by documentation session.
Kepada Bapak Ibu tamu undangan, Mr. Inyoman Sucitrawan SHMH yang mewakili, Dr. Masahiro Suzuki, Dr. Duk Kwang Lee, dan juga Profesor Dr. Bayu Dwi Anggono SHMH untuk bisa maju ke depan untuk melaksanakan penyerahan cindera mata dan juga sesi dokumentasi bersama. Terima kasih kepada para tim undangan untuk bisa duduk di tempat masing-masing.
Okay, thank you so much for those speakers. That will be a discussion later with us and this morning. But before we move to the plenary session, please enjoy the solo vocal from Miss Gabby Januar Dwianti. For Miss Gabby, the time is yours.
There goes my heart beating, 'cause you are the reason. Losing my sleep, please come. There goes my mind racing, and you are the reason that I'm still breathing. Oh, now climb every mountain, swim every ocean, just to be with you and fix what I've broken. Oh, 'cause I need you to see that you are the reason. There goes my hand shaking, and you are the reason. My heart keeps bleeding, and each and every, if I could turn back the clock, I make sure the light beat the door. Spend every hour of every day keeping you safe. Climb every mountain, swim every ocean, just to be with you and fix what I've broken. Oh, 'cause I need you to see that you are the reason. You are the reason. I need you to hold me tonight. I climb every mountain, swim every ocean, just to be with you and fix what I've broken. Oh, 'cause I need you to see that you are the reason.
Thank you to Miss Gabby for the solo vocal. And we would like to say thank you to all the attendees from the Dean of the Faculty of Law, Director of the University of Jember to attend the second International Conference on Law and Society today. Okay. Moving on to the next agenda, we have the plenary session. In this plenary session, we will hear some materials that our speakers will deliver. They are, first, we have the Honorable Dr. Masahiro Suzuki from Central Queensland University, Australia.
Second, the Honorable Dr. Tuk Kwang Lee from Thammasat University, Thailand.
The third, we have Igede Widiana Suwarda, SH MHum PhD from University of Jember, Indonesia. This plenary session will be conducted by our moderator today, the Honorable Dr. Galuh Puspaningrum MH, as the lecturer of Faculty of Law, University of Jember. To Dr. Galuh Puspaningrum, please have a seat.
Thank you, Master of Ceremony. Ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Nama Budaya, Salam Kebajikan, Salam Rahayu. Good morning, everyone. Honorable Dr. Iwan Taruna, MN IPM, Rector University of Jember, the Honorable of Professor Dr. Bayu Dwi Anggono, SHMH, as the Dean of Faculty of Law, Jember University, the Honorable Professor Dr. Sanitiar Burhanuddin, SHMM, Attorney General of the Republic Indonesia, as a keynote speaker, the Honorable Mr. Inyoman Sucitrawan, SHMH, State Attorney, Jember. The Honorable our speaker, Mr. Masahiro Suzuki, PhD, from Central Queensland University, Australia, Mr. Dr. Tuk Kwang Lee, Faculty of Law, Thammasat University, and Mr. Igede Widiana Suwarda, PhD, from Law Faculty, Jember University. Ladies and gentlemen, welcome to the second International Conference on Law and Society, Restorative Justice, Theory and Practice in Multicultural Society in 2022. My name is Galuh Puspaningrum. Now I'm going to be the moderator today. We know that restorative justice is one of the principles of law enforcement, settling cases which can be used as instrument of recovering. Restorative justice also means of mediation and reconciliation. And now Indonesia is starting to implement restorative justice. Through this conference, there are 3 speakers who are already with us. We have Dr. Masahiro Suzuki from Central Queensland University, Australia. Welcome to Faculty of Law, Jember University. And the second speaker, Dr. Tuk Kwang Lee from Faculty of Law, Thammasat University. Welcome again. And see you again, Mr. Tuk Kwang Lee. Yeah, I have been to Thammasat in a few ago. Yeah. And so my teacher, my lecturer, Mr. Igede Widiana Suwarda, BSc, from Law Faculty, Jember University. Okay, and now I would like to share the rules of this session. In this plenary session, we have 60 minutes presentation and 30 minutes for Q&A. Yeah. Is too long or short? Yeah. 30 it's speaker. Yeah, it's speaker 20 minutes. Yeah. 20 minutes it's speaker. This session is 60 minutes presentation. Yeah. and 30 minutes for Q&A. And each speaker will talk around 20 minutes. Yeah. And we have 30 minutes for Q&A after the presentation. Now, I'm going to invite Mr. Dr. Masahiro Suzuki. Firstly, I will share his profile. Yeah, Dr. Masahiro Suzuki as a lecturer, College of Law, Criminology and Justice, School of Business Law and Law, Central Queensland University, Australia, since 2019 at present. Its curriculum so long. Yeah. He's complete his education LLB Kyushu University in 2011 and the last study in PhD Griffith University. Yeah, people or process, and his thesis people or process desistent journeys and measure in youth restorative justice conference. He has research and teaching interests are restorative justice, youth offending, decisions, victimology, criminology in Asia, criminological theory, and all. He also got awards in 2018 until 2021 in research on restorative justice. And he also got many grants, yeah, and fellowship, scholarship. So he has many experience in publication, presentation, and service experience and professional affiliation, such as Australian and New Zealand Society of Criminology. Since 2018 at present, Asian Criminology Society and Japanese Association of Sociological Criminology. So Dr. Masahiro Suzuki, you have 20 minutes to present the material. Yeah, stand up or, yeah. He would like to share about restorative justice theory for multicultural society. So, Mr. Masahiro, please, the floor is yours.
Okay, so while we are waiting for my PowerPoint presentation is ready, so hello everyone, my name is Masahiro Suzuki. I am originally from Japan, as you can see, guess from my family name Suzuki, but currently I'm a lecturer in criminology at Queensland University, Australia. So it is my greatest honor to be invited at this international conference. So I'd like to thank the conference committee member for their hard work for the past few weeks and to get me invited here to this beautiful country and to this beautiful campus. I'm already liking it, so I'm already looking forward to coming back here in the near future. I also like to thank my dear friend Gaide here. We both did our PhD in Australia, although different institutions. So we met at conference twice, I believe. And then the last time we met was the Philippines in 2019. And at the time he said, you know, he's gonna invite me to Indonesia. But as you know, COVID happened, so you know this sort of blown away. But now we're getting back to normal. Then here I am. So I'm very pleased to be here. So thank you for inviting me again. Right. So today, in line with the theme of the conference, what I'm going to talk about is about my research on the theory of restorative justice, and I'm also talk about the implications for the implication of the theory of restorative justice in a multicultural society like Indonesia. Can you go to the next slide, please? Yep. So my presentation has three aims. The first, I'm going to provide a brief summary of the current theoretical understanding of RJ to highlight the theoretical gap in the literature on RJ. And second, I present the theoretical models of RJ that I have developed so far. And finally, at the end of my presentation, I would offer questions to provoke and advance further discussions over the role and the potential of restorative justice in a multicultural society like Indonesia. So since I first heard that my presentation is gonna be 30 minutes, but now I'm told it's 20 minutes, so I'm gonna talk real fast or may skip some slides. So my apologies in advance. Can you go to the next slide, please? Right, so what do we know about RJ? So I do not know about the extent to which you guys know about RJ. But let me summarize the key point of RJ so that we are on the same page. Essentially, restorative justice is a new justice response that involves a face-to-face dialogue between victims and offenders. And RJ is widely used in the criminal justice system in many countries, perhaps including Indonesia. There are many evaluation studies, and according to these studies, RJ has many strengths over conventional justice in terms of satisfaction, fairness, accountability, legitimacy, agreement compliance, and so on. And RJ practice is expanding. So for example, RJ is now used for serious crime, including sexual violence, or even for murder or homicide. And RJ practice has started in the Western countries like Australia, US, and Canada, United States. But RJ practices are evolving in other regions, including Asia. Next slide, please. Right, so in terms of the theory of RJ, the perhaps most well-known theory is John Braithwaite reintegrative shaming. So since I do not have much time, so put simply, this theory posits that there are two types of shaming: stigmatizing shaming and reintegrative shaming. So stigmatizing shaming involves disapproval of offenders as a person. On the other hand, reintegrative shaming involves disapproval of offenders' act while approving offenders as a person. So Braithwaite argued that reintegrative shaming is more effective in rehabilitating offenders than stigmatizing shaming, which is typically used in the criminal justice system, retributive justice system. And research shows that RJ is more likely to utilize reintegrative shaming, and as a result, more offenders feel a desire to repay the society and victims. And however, reintegrative shaming is critiqued because it was offender-centered, although RJ is an interactive process that involves more than offenders. It involves particularly victims and community members. Next slide, please. All right, so another widely applied theory of RJ is procedural justice by Tyler. According to this theory, people obey the law when they feel more fairness in their treatment by the authorities, such as police or court. And research shows that offenders who participate in restorative justice are more likely to feel that they are treated with respect than those in court. So like reintegrative shaming, procedural justice theory was widely tested in restorative justice research. So among these studies, I want to mention the research by Bankamp and Wemmers, who explored what contribute to victim satisfaction in restorative justice. So by interviewing 34 victims of violent crime who participated in victim-offender mediation in Canada and Belgium, they found that there are two categories of factors that are associated with victim satisfaction in restorative justice. And the first group consists of procedural justice elements, such as giving a voice or being treated fairly. The other group which is more important to this slide, to this presentation, are the factors that are unique to RJ, such as care for victims, providing information, and receiving answers from offenders. So this finding implies that we can utilize existing theories, existing criminological theories to explain RJ, but maybe only partially, because they are not invented specifically for restorative justice, and they can only explain some segment of RJ. Next slide, please. Right, so what do we not know about RJ? So what we know about RJ is that it is widely practiced, but there's a lack of research or link between theory and practice of RJ. So in other words, we still do not know how, under what circumstances, and for whom RJ works. So more specifically, as Bademore and Gordon argued more than a decade ago, what is the independent variable of RJ? So what are the core elements of RJ that influence offenders and victims' well-being and behaviors? So as I discussed elsewhere in my publications, I think this question matters because most existing studies of RJ were conducted in the context of what works. So they explored the effectiveness of RJ, what the impact of RJ. So this focus is understandable because RJ was initially proposed as an alternative to the conventional justice approaches. So advocates needed to demonstrate the superiority of RJ over conventional justice approaches. Now, more than 2 decades have passed, and we have accumulated evidence of the strengths of RJ. RJ is better than conventional justice. So what is the next step? So I would say it is to shift our focus in restorative justice research to how it works. What is the mechanism whereby RJ produce benefits for victims and offenders? Right, next slide, please. Right. So what sorts of research on how RJ works exist? So not surprisingly, only a few. So among these, today, I would like to introduce my research on topic in detail, although I will have to skip some of the slide due to the time constraints. So as you can see, over the past 5 years, I have exploring how restorative justice works. So in total, I have developed 6 concepts, theoretical frameworks, and models so far. And today, let me focus on the most recent, probably 2 theoretical models here, because I do not have much time. So not only because they are new, but also because I plan to conduct a research project to test these theoretical models over the next 2 years. So I welcome any suggestions, questions, or feedback on my theoretical models at the end of my presentation or at the end of this plenary sessions. Right, so next slide, please. Perhaps skip this one. All right, I think this one. Yeah, okay, good. Right, so let me start with this model. And this is what we call a process-based model of self-forgiveness in RJ. This is the most theoretical model I have developed with my colleague from my PhD program. So when you hear the word forgiveness, what normally comes to your mind is forgiveness between people, right? So interpersonal forgiveness. But forgiveness is a multi-dimensional concept that including not only interpersonal dimension, but also intrapersonal dimension. So put simply, self-forgiveness means forgiving self, forgive yourself. So self-forgiveness is important for offenders in restorative justice, I would say, because as a result of offending, offenders suffer painful, destructive after effect because as a result of their offending, they carry shame, guilt, and self-condemnation for their offending. So by achieving self-forgiveness, offenders can heal from these self-created harms. Also, by achieving self-forgiveness, offenders can start to feel, act, think constructively toward the self and sees themselves worthy. So I'm not sure how many people, if this applies to you, but if you are familiar with the desistance literature in criminology, you may notice the link between the self-forgiveness and the desistance. Because achieving self-forgiveness involves reconstruction of morality and commitment to future law-abiding behavior. So, therefore, offenders who achieve self-forgiveness may be more likely to desist from crime, because according to the recent literature on desistance from crime, normally this means stopping offending, requires identity transformation in a pro-social way. Because when you commit the offense, you have developed your identity as a deviant. So you have to change this deviant identity to pro-social one, like law-abiding citizens. Anyway, so what is needed to achieve self-forgiveness, and how is self-forgiveness related to RJ? So RJ can promote self-forgiveness by helping offenders to meet 4 conditions to achieve self-forgiveness. As you can see on your right-hand side in this slide, this is a model. So first, acceptance of responsibility is one of the key elements. So to achieve self-forgiveness, offenders first need to accept responsibility for their offending, because acceptance of responsibility distinguishes genuine self-forgiveness from pseudo self-forgiveness. So pseudo self-forgiveness means like a fake self-forgiveness. So pseudo self-forgiveness occurs when offenders deny or partially acknowledge their responsibility, and it produces no benefit of self-forgiveness. RJ can help offenders to take full responsibility, because in RJ, offenders are treated and listened to fairly, which helps offenders develop remorse. And second key element in this model is the existence of supporters. And to achieve self-forgiveness, offenders need to recognize that their offending is forgivable, and also that they are worthy of love, respect, and compassion despite their heinous offending. So research indicates that this message can come from victims, family members, and close friends. And as you may know, these people, family, victims, and close friends, participate in restorative justice as a support member for offenders. And they can convey the offender such a message, you offended, but you are still worthy person. These people, these supporters can convey that message. Right. And then third key element is a reconciliation with negative emotions. Accepting responsibility for offending involves self-condemnation, because as you can imagine, you have to admit that you did wrong in the past, right? So you have to condemn yourself, your past behavior. So this acknowledgement of past offending normally produces negative emotions such as shame and guilt. You did wrong. You feel shame or guilt, right? And so RJ can help offenders to discharge these negative emotions, and discharging these negative emotions is necessary because it's not healthy. So RJ can help offenders to discharge these negative emotions because RJ encourages acceptance of offenders as a person as per the reintegrative shaming theory put forward by John Braithwaite. And final key element is reparative agreement. The research shows that reparative behaviors can help offenders achieve self-forgiveness. Well, this is understandable because you did wrong in the past. So what you have to do is to make amends. by doing so, you can change your self-identity from deviant to the law-abiding citizen. In this regard, I mean, the repellation, RJ can be helpful because in RJ, participants normally create an agreement plan for what offenders should do to make amends to victims or community members or even society. And research shows that there's very high compliance rate for the completion of this agreement plan as a result of restorative justice. So, given the relationship between self-forgiveness and desistance, and the relationship between self-forgiveness and RJ, it may be self-forgiveness that facilitates desistance from crime through restorative justice. And indeed, a model on your right-hand side in the slide shows three main paths toward desistance or reoffending after RJ. So these three paths are differentiated by the extent to which offenders accept their responsibility. Because acknowledging responsibility is the most important condition to achieve self-forgiveness. So this comes first before other key elements. So these three paths include, as you can see, full responsibility, partial responsibility, and denial of responsibility. So when offenders accept their full responsibility for what they have done to victims in restorative justice, they are in the path of achieving genuine self-forgiveness. And this process can be facilitated or promoted further by releasing negative emotions, receiving care from supporters, and completing the agreement plan in restorative justice. And as you can imagine, once offenders achieve genuine self-forgiveness, they have a transformed identity of positive self and reconstructed morality. So these together encourage offenders to commit to future law-abiding behaviors. So this may result in desistance after RJ, but the offenders have transformed their identity from deviants to moral and law-abiding citizens. But as you may know, not surprisingly, not all offenders accept their responsibility in RJ. Some offenders just deny or partially admit their offending. So when this happens, when offenders deny their responsibility or only partially acknowledge their responsibility, what they can achieve is either pseudo self-forgiveness or no self-forgiveness. And without genuine self-forgiveness, offenders may not reflect their own morality. So because they cannot forgive themselves because they do not think deeply about what they have done in the past. As a result, they may fail to transform the identity as a moral monster, as a result of offending, to moral citizen. And then this may result in reoffending after RJ. So this is one of the models I have developed. Okay, can you go to the next slide? All right, so the next model I would like to introduce in my plenary speech today is the theoretical framework of victim recovery in restorative justice. Well, surprisingly enough, there's not so many studies on the victims in restorative justice, although RJ has emerged to address the critics of conventional justice system to neglect victims in its proceedings.
Mr. Masahiro, you have 10
Fine.
minutes again.
10 minutes.
Yeah, 10
10
minutes.
minutes. Oh yeah, I can finish that. Yeah, sure.
Okay, thank you.
So anyway, where was I? All right, so this model on your right-hand side in slide consists of two core recovery factors. So I have developed this model to fill the gap in the literature because, as I said, there's virtually no research on victims in restorative justice. So we do not know how restorative justice can help victims restore their emotional harms or get recovered from victimization. Anyway, so two core recovery factors. And the first core recovery factor is making meaning of harm through validation. So after victimization, victims tend to lose their sense of control over their bodies and narratives. Because before victimization, they have the control over their body. But as a result of offending, they have lost it. They have deprived of it by the offenders. So as a result of victimization, they start to feel insecure and even blame themselves for their victimization. Victims tend to think it is their fault that they are victimized. So the most important concern for victims to get recovered is to re-establish their narrative of life stories by making meaning of the harm caused to them. So they have to recreate the story of the victimization. It is a bad thing happened to me, but I can recreate this story and I can learn something from it. So this is a recreating the story of victimization. All right, so that victims can make meaning of the harm caused to them. So victims learn something from victimization. So the second core recovery factor in this model is reclaiming the self through dialogue. So as a result of victimization, the self of victims, the identity of victims, is damaged because victimization has not only physical impact, but also ontological impact, including an existential threat to the identity of victims and loss of the sense of autonomy. So victimization impact mentally and psychologically, in addition to physical impact. So what is needed for recovery from victimization is to salvage the damaged self by reclaiming the self that is damaged by victimization. Because recreating the self, re-establishing the self, re-establishing the identity for themselves can help victims regain the belief in themselves and the perception of control over traumatic adversity. So RJ can support the production of these two core recovery factors because RJ is a dialogue-driven process rather than settlement-driven. So the focus of RJ is on the dialogue between victims and offenders. So they're going to talk about what had happened and what should be done to repair the harm caused by crime. So because this RJ is a dialogue-driven process, victims are given opportunity to ask the why me question. Why am I targeted by this offender? And also they can receive the answers about why the offense had happened and why they are targeted as a victims. And in addition, RJ encourages offenders to actively take responsibility for what they have done to the victims by nurturing repentance or remorse within offenders. So having an acknowledgement of their victimization and knowing that victimization is not their fault, it's just the offender's fault, it allows victims to validate their victimization, thereby making sense of the harm caused to them. So victims can recreate the story of their victimization. And in RJ process, victims are also given an opportunity to not only ask questions about offending, but also to express their feelings about offending. How they can explain how much they are hurt by their offending and what they demand for the offenders after this process, and so on. And research shows that giving a voice is therapeutic, like as the therapy, like a therapy, by discharging the negative emotions attributed to victimization. In addition to the two core factors that may be essential to the recovery process in RJ, there are also enabling factors that can promote the victim recovery process in RJ. For example, one such enabling factor may be resilience. So the resilience is the victim's ability to get recovered by themselves without any help. So possessing resilience, according to research, is helpful in overcoming the traumatic adversity of victimization. And compensation in RJ may also support the victim recovery process because receiving material reparation, like a compensation for like money, is one of the important needs for victims in the victimological literature. And the third enabling factor for the victim recovery in restorative justice may be what is called support networks, which refers to emotional and substantive assistance from the important persons, such as community members, friends, or families. So establishing support networks in the recovery process is advantageous for the victim recovery because regardless of whether it is informal or formal, support networks can offer material, emotional, and social support for the victim's recovery process. And finally, the forgiveness may support the victim recovery process because forgiveness can help victims let go of the experiences of victimization and declare a personal victory over the negative emotions attributed to traumatic victimization. So based on these core and enabling factors, perhaps we could explain the victim recovery process in RJ. So once victims consent to participate, participation in RJ is voluntary, the path to recovery from victimization may begin. So in RJ, the recovery process may be facilitated mainly by the core recovery process. So this core recovery process in RJ involves victims making meaning of harm through validation of their victimization and the reclaiming self through the dialogue to express their feelings about their victimization. And as I mentioned, in relation to the enabling factors, the victim recovery process in RJ is further facilitated if any enabling factors are present in RJ. Right, can you go to the next slide? Okay, so this is gonna be the final slide. So in this presentation, I looked really quickly at the current theoretical understanding of RJ. So we know that RJ has many benefits, but there are many things that require further examination. So one of them is what the theory of RJ is. We cannot answer this question until we figure out how restorative justice works. So to fill these gaps in the literature, I have offered new theoretical frameworks of RJ in this presentation, which are published anyway. So, relating my presentation to the theme of this conference, I think these questions in how restorative justice works matter and relevant to the practice of RJ in a multicultural society like Indonesia. Because as I mentioned at the beginning of my presentation, RJ is evolving, RJ is developing and expanding in Asia, perhaps including Indonesia. But most of what we know about RJ, particularly its effect and the mechanisms, is limited to the Western context because the vast majority of empirical research on RJ has been done in the Western countries like Australia, US, Canada, UK, and so on. So this means that we do not know how restorative justice works in other contexts, particularly in Asia, because we have different cultures, right? We all adhere to the rule of law and other legal principles. But the justice concept, the system, procedure, and practices are closely connected to the history, culture, customs, and religion of each country. So like Indonesia, you have your own set of justice concept, systems, procedures, and practices. So just importing seemingly innovative justice response may not necessarily work because it may not be compatible with the country's culture, history, or traditional conflict resolution process or method. So therefore, I think we should first identify the mechanisms whereby IJ helps victims and offenders. And once they are identified, we can start importing foreign justice practices, possibly with some modifications. So I would like to, can you go to the next slide, please? Yeah, it's just references. There's a lot, so sorry about small text font size. Anyway, so I'd like to conclude to provoke, so my presentation, the aim of my presentation is provoke further discussions over the role and the potential of restorative justice in a multicultural society like in Indonesia. And I believe the first step to use restorative justice in a multicultural society like Indonesia is to identify how restorative justice works and develop a theory of restorative justice. At last, so once again, thank you for inviting me to this beautiful country and campus, and thank you for giving me this fantastic opportunity to talk here. So I hope you all enjoy my plenary speech, and thank you for listening.
Thank you very much, Mr. Masahiro, for giving us such informative and interesting presentation. The next session, now I'm going to invite Dr. Du Quang Lee from Faculty of Law, Thammasat University. Firstly, I will show your profile. Dr. Du Quang Lee studied political science, history and philosophy at Friedrich Alexander University of Erlangen-Nuremberg, Germany, where he received his PhD with a dissertation on Chinese constitutional thinking. He works at the German Southeast Asian Center of Excellence for Public Policy and Good Government, CBG. He served as project manager, deputy head of CBG's Peace and Security Center, Asia in Review, regional editor for East Asia, and member of the editorial board of CBG's European Asian Journal of Law and Governance. His focus of research lies on comparative constitutional politics, rule of law, public policy, and good government with special focus of China. Dr. Du Quang Lee, you have 30 minutes to present the materials, so please, the floor is yours.
Yes, thank you very much for this kind introduction, and thank you very much to Dr. Gede for his kind invitation. It's really, really good to be back in Jember after many years COVID break. As you have been also informed, I am from CPG, the German Southeast Asian Center of Governance and Public Policy and Good Governance. And since 2010 and 11, we have been cooperating nicely with the Faculty of Law of Jember universities and engaged in many activities, sending students to Bangkok, to Jember, to Germany for short programs, trainings, and we hope and we think that we will continue to do so from next year on, and see one of you, some of you sooner or later in Bangkok, and that would be great. Some of those who have been with us in Bangkok are here. I'm very pleased to see them. So thank you again for this opportunity to be here, of having me. I was asked by Dr. Gede to make a presentation which is unlike that of Dr. Masahiro, because he was presenting conceptual, theoretical models. I was asked to present you restorative justice from a time perspective, where I'm working to discuss with you how is restorative justice done in Bangkok or in Thailand. Can I have the slides, please? Yes, thank you very much. So that's why my presentation is titled Restorative Justice and Victim Offender Mediation, a Perspective from Thailand. And my presentation is sketch structures into three parts. the first part, I will give a source of meaning or a description of what I mean by restorative justice in Thailand, in the Thailand context, because that is what I think is now currently predominantly discussed as restorative justice in Thailand by people who are engaged in the work of restorative justice, officials, NGOs, local leaders, local communities. Yeah? So this is the first part, some understanding of what I mean by restorative justice, and it's already indicated in the title. What I mean by, when I'm talking about restorative justice, I talk about victim offender mediation. I will explain the term later. The second part is, as you are law students here, I will give you short insights into the legal framework of victim offender mediation or justice, RJ, in Thailand. Yeah, the base, they are forming the basis of the work on RJ, victim offender mediation in Thailand. And the third part is then to discuss some issues, challenges, problems, RJ, which has developed quite well in the past 20 years, is facing, and where are the opportunities for improvement, space for adjustments and development. Okay? So next slide, please. Before I start with the terms description, just let me add for your information, maybe also interesting for you and you, Dr. Masiro, that at CPG we have recently found a mediation center, which is dealing with the problem how to bring conflicting parties together and find a solution. So we offer, our center offers services to bring conflicting, disputing parties to a table and discuss, and to enter into a process of dialogue and attempt to resolving conflicts. And that applies to commercial disputes, but also family law, judicial disputes, but also political disputes. We have at our center now 4 mediators who will be able to provide these services in 4 languages: German, Chinese, Thailand, and Thai and English. With that, I will go now into my presentation, and first of all start with what I mean by RJ. RJ is in this presentation, a form of victim offender mediation in criminal matters. Yeah, for this presentation, for this conference, it's victim offender mediation in criminal matters. What I mean by mediation, you can see here. I have to read it with you. So mediation is for me a structured, interactive process. Yeah? A process with an impartial and neutral third party. That's very important. You have 2 parties and one in the mid trying to help these parties to come to a resolution of their dispute or conflict. Yeah? Another element is that for mediation, you have to use specific informed ways of communicating and negotiating in the hands of the mediator. The mediator, the third party, must be very well informed and familiar with these negotiations and communication techniques and methods. Another important element is that the participants are encouraged to actively take part in this dialogue. Yeah? They are actively interested in this dialogue because they are voluntarily doing that. They are not forced. They are not forced to do that. They are not pressured to do that. They are willing to enter into this dialogue freely. Yeah. And last but not least, the mediation is focused on meeting meeting the needs and interests and rights of the two parties. So this is mediation. Yeah, this is mediation from my perspective. Next slide, please. Now, RJ as victim offender mediation in criminal matters. Yeah? Now, the next step is, what is then RJ as a mediation, as a form of mediation? That is then victim offender mediation. And now, the goals. Now, a further description of VOM, so to speak. The goals, the one goal is, of course, at the end of the day, at the end of the mediation, you have a result, a settlement, an agreement between parties. Yeah? And in this criminal matters specific case, it's especially about the monetary compensation of the victim. Yeah. As Dr. Mahasio explained, that one major element of the victim in RJ to be satisfied with RJ processes, is that they get a compensation that is sufficient, satisfying them. Yeah? So this is the major goal, yeah, in victim offender mediation. Both sides feel that in this process of mediation, they are taken serious in terms of what they want to achieve, what they want to express, what they want to do. Yeah? The goal is then also to reduce the conflict, consequences, and subsequent conflicts. So prevention, prevention that the offender does the crime again, for example. Yeah? And ensuring the autonomy of the parties to the crime. Again, here, what I mean, they are voluntarily, they are freely in this mediation, and they are not pressured to do so. And of course, one important thing for victim offender mediation, what happens after the agreement is made? How it is going to be enforced? Yeah? Who is going to overview, monitor the enforcement, the fulfillment of the agreement? Yeah? This is a big problem. We come later to that, yeah, in this part. Yeah, and avoidance of injustice means further injustice. This is overlapping with this here. So again, to prevent that the offender does the crime again, yeah, or that the victim is re-victimized in this dialogue, yeah, when it feels pressure from the offender. Yeah, when the dialogue is taking part, the conferencing is taking part, and the offender is using pressure to process his interest in this mediation. Yeah? So this is avoidance of injustice. Next slide, please. So now we, based on this conceptual terminology of victim offender mediation, I will now look into the legal framework or parts of the legal framework on which RJ or victim offender mediation processes are done. Okay, thank you. I see that it's maybe too big. I would ask you to scroll up then. So let me give you, before I go into the details, a short background information. RJ or victim offender mediation has been in place roughly prominently since 20 years. 20 years, yeah, 20 years. In terms of the legal framework, I need to mention that in 1997, Thailand got a new constitution, which is already not anymore in force. But in 1997, there was a new constitution, and this constitution put some emphasis on the rights of the people. Yeah. Prior to that 1997 constitution, Thailand was an authoritarian country. The constitution tried to to ease that problem by putting more effort on looking into the rights of the people. In this political and constitutional atmosphere, yeah, the justice system was also reformed. Yeah, also reformed. Yeah, the Court of Justice was now separated from the Ministry of Justice as an independent judicial branch or agency. And within that frame, people thought about the reform of the country's justice system, justice administration system, justice administration processes. And then they discovered victim-offender mediation to make use of that. Yeah? So for example, Dispute Mediation Act BE 2562, this is the Thai way to count the years. BE means Buddha existence. Yeah, we have the Western number here, 2019. This is really, I don't have time to go into details, but I just want to say, to inform you that all these laws and regulations I will go through highlight a lot of the mediation term, the mediation idea. Yeah, so that's why I put that in the beginning. So for example, in section 21, if any one party to the dispute decides a mediation, the party shall file a request to the entity that mediates. Such entity mediating a dispute shall ask for the consent of the other to participate in the mediation. If the other party does not decide to participate in the mediation procedure, the mediating entity shall dispose such mediation request and inform the party making such. So that means what I want to highlight, they come together freely. Yeah, if one party says no, then no mediation. Yeah, so this is the one element of the concept. To mediate a criminal dispute, so here we have the criminal dispute, yeah, criminal matters, criminal dispute, in the context of mediation, according to this law, according to the Dispute Mediation Act. Yeah. Can you scroll up, please? So then we have, the next section is 36, again in this law, and here you see again, the Liberties Protection Department is the responsible agency, yeah, to initiate the mediation. Yeah, or the public prosecutor or the court can also initiate that. So we have different actors here who can initiate a mediation for criminal issues according to this law. Next slide, please. So then another law of 1991. We have the State Administration Act, so the law about how to run administration. And here we see also again the word mediation services for peace and society. Yeah? So a district, a sub-level of the government, yeah, can also have mediation to solve problems pertaining to peace in society. Yeah? So this is much what RJ is also about, yeah? To find a solution between offender and victim to reach peace and harmony in the society, but also in the community both are living in. Yeah? We have also the section 61/3, again relating this mediation to the criminal offenses. Yeah. So and here we have the district chief shall be the mediator. Yeah? So you see all these laws, they don't use the word RJ. They don't use restorative justice. They use the word mediation, but in essence, they talk about the same. Yeah, bring two people freely together to discuss a settlement for peace in society, in the community, yeah, and to satisfy the compensation needs of the victim. Next slide, please. This is not a law, this is a regulation on the Judicial Administration Commission on mediation. Again, you have the word mediation here. Yeah? Grant the victim the right to participate in the mediation of a criminal case. Yeah? Again, they don't use the word restorative justice, they use the mediation word for a criminal case, for a criminal offense. Yeah? Next slide, please. Another regulation from 2012. So this concerns the prosecutor, and here again the public prosecutor in charge of the case shall conduct the mediation on conciliation fairly and impartially. You see, again they don't use the word RJ, they use mediation, and the components are fair and impartial. Yeah? And shall do not anything to persuade, promise, threaten, deceive, or do other legal things in order to make any party give their consent. Again, no pressure can be imposed on the parties to participate. Yeah? So all these elements are elements of restorative justice, but in the Thai context, they use the term mediation. Yeah? And mediation as victim offender mediation in criminal cases. Next slide, please. Another act, Juvenile and Family Court Procedure Act. So this act concerns juvenile, young people committing a crime, an offense. And you see here, I have put this because this is the only, to my knowledge, the only regulation or law which use the term restorative justice in the text. Yeah, to my knowledge until now. Maybe there is no developments, but right now this is the only act to use restorative justice. As I said, they have picked up this idea or this concept in 2010, well, because they are rethinking how to do with our juvenile offenders. Yeah, how to best protect them, how to best rehabilitate them. Yeah, so that's why they put the word restorative justice here. And again, the operation of restorative justice is the operation that prioritizes here victim-centered, prioritizes alleviating suffering or resolving the dispute caused on the ground of illegal acts by making reparation for the victim and community. Yeah, again, the word is reparation, compensation. Yeah, this is the important element to do. Next slide, please. Okay, so this was the second part, yeah, the legal framework on the basis of which Thailand is, or Thai institutions, Thai people, Thai practitioners, Thai prosecutors, Thai NGO people conduct victim offender mediation processes or RJ processes. Yeah, and you saw that I presented 3 or 4 laws, 2 or 3 clauses, and this highlights one big problem right now in Thailand. This is the legal framework itself, and I mentioned it here as the absence of a comprehensive law. There is not right now no single one law that covers all the issues of RJ or victim offender mediation. Many regulations are put in this law, in this regulation, and there's no standard. There's no standard how to proceed RJ processes or a victim offender mediation interventions. Yeah, for some cases this organization is leading. For some other cases, this another organization like the prosecutor or the district officer can be mediator. They have no standard on how to implement, yeah, mediation processes, programs. Yeah, they don't have a standard procedure plan, what to do first, second, third. They don't have a standard, a law on provisions telling those engaging in RJ or victim mediation, victim of offender mediation, how to safeguard the rights of the victim, especially the rights of children. Yeah. So there's no standard catalog how to protect children or young people then they enter in such a mediation, because they have, of course, more needs to be cared for. For example, if they meet the offender, they are scared, they have fear pressure. How to protect them in this case, yeah, or other things like this. There's no standard in the Thai legal framework to operate on. So the many people engaging in RJ or mediation in Thailand are demanding the government to enact a law that provides a uniform legal definitions and a standard framework to guide restorative justice practices in criminal matters. That's the first issue. I don't know how the situation in Indonesia is, but maybe we can discuss it later if you have a uniform legal definition. Another issue discussed among RJ community, the network, is public awareness that is very low or comparatively low. Yeah, people in Thailand have somehow heard of restorative justice or victim offender mediation, but they don't really know, are they entitled? Who is entitled to enter such a thing? Does it cost money? Is it for free? What has to be done in such a dialogue? Yeah, so that's why people engaging in this area demand that more has to be done in terms of public information and education. Restorative justice is until now not a subject of any studies at universities. Yeah? It is not taught in high school. Yeah? And the media are also very reluctant to promote this. So this is a problem. Next problem. Still 10 minutes? Okay, then I will finish. Okay, with time. So the next issue to discuss in Thailand, that is discussed, is program implementation. Yeah, program. This is related to the first point that we don't have a standard definition even of what restorative justice is. So that's why when implementing the program, there's a quite, not a mess, but people, so to speak, every single agency does the way it thinks it can do the best way, yeah, but there is no standard in the implementation, yeah, and some agencies don't have people, for example, to look after the compliance with the agreement, for example, that they stop with the agreement because they don't have the possibility to look if the offender is doing what he promised in the agreement, for example, to pay the money regularly or to work for the community, yeah, or to meet with the victim every month, yeah. They don't have the possibility to check this. And then what happens normally is that the victim calls the agency, the official, hello, my offender did not meet me today. What to do? I will call him. That's all what they can do. Yeah. So this is also a problem. So that's why people want to have a legal duty for law enforcement and justice officials to do this. Yeah. You need to do that. Yeah. You cannot say, okay, I don't have enough manpower to do that. Yeah. They want to have a law, but that comes then, of course, with a problem of funding. Yeah? Because if you don't have the people you cannot do, even if you have a law. But before that, you should have a law, yeah, to force people to check whether this agreement is met or not. Yeah? And there are many more, because program implementation is also collecting data about the cases, yeah, the processes, who is involved, what is the agreement, how is it followed. There's also no standardized way to do that. Yeah, many people, many officials still do the handwriting on this case monitoring, yeah, and it's still not digitalized. Yeah, these problems. Yeah, capacity building. Yeah, this is also a discussed topic. People involved in restorative justice or victim offender mediation don't have enough knowledge. Simply, people, officials, they got their first course 10 years ago, yeah, and then there was nothing, no follow-up. Yeah, they don't know the legal developments, the latest requirements. They don't know about international human rights standards related to restorative justice, and so on and so on. Yeah, so they work really on a basis where people think, okay, this is not update. Yeah. So yeah, again, the demand is trainings on a regular basis, high quality training that also not only teach about their duties and obligations, but also provide them technical skills. Yeah, technical skills, how to talk to the offender is different from how to talk to the victim. There needs to be skills, second skills, so to speak. Yeah, how to set up a meeting. Yeah, for that you also need skills. You just cannot just go into the meeting without a plan. Who's speaking first? Who's the second? How much time? What are the topics? Yeah, these skills has to be developed too in capacity building. And last but not least, always the problem: too less money. Too less money for all these big ambitions and goals and development targets. Not enough money, because the official says, yeah, I want to check if the agreement is fulfilled, but I have to do 10 other cases here, and I need 3 more people sitting next to me to do that. Yeah? Or you want me to digitalize the data? Yeah, sure. Buy me a computer. Yeah, these things. Yeah. So strategic funding is requested, and the idea is that one of the ideas is to ask the government to make a law. Make a law. Every year you give me that amount of money for restorative justice. Yeah. Or the second idea is we already have some national funds for criminal matters, criminal justice administration, criminal justice matters. Just put in this law an amendment and say that part of that money shall be dedicated specifically towards restorative justice programs, measures, activities. So this is the strategic funding idea of people who are seeing the problem that Thailand's development in restorative justice, victim offender mediation has started, has developed, but it's not progressing anymore because of these problems. Yeah, people involved in these mediations give good response. They say that helps them. The victims say that helps them. The practitioners say it's progressing. There's participation. Even offender say it's useful for them. With offenders, the results are mixed. But basically, there is, let's say, there is a will of many people to go this road, to further this development. But they also see these problems. Yeah? They also see these problems and try to work on that, try to build a network of involved stakeholders. Yeah, this is the latest development I can tell you in Thailand, especially the Thai Institute, the Thai Institute for Justice is a leading agency, yeah, that wants to bring together a network platform of government agencies, prosecutors, courts, NGO people, practitioners, victims, and offenders, to pull them together and make a master plan, action plan to solve these problems. As I said, I'm not sure how the situation is in Indonesia, but I'm happy to discuss that from the Thai perspective. With that, I conclude. Thank you for your attention.
Thank you very much, Mr. Dukwang Lee, for your information, for interesting material, yeah, RG in Thailand. Now, I'm going to invite Mr. Igede Widyana Suharda, PhD, Faculty of Law, Jember University. He will explain about RG in Indonesia, about theory and concept. So before he speak, I will read his profile. He is a Vice Dean of Academic Fields and also lecturer. Mr. Igede, he finished PhD in Justice in Queensland University of Technology, Faculty of Law. His thesis title is an examination of Indonesian prison officers, experiences on their dedications towards better practice. He is a lecturer on criminal law, Department Faculty of Law. His main interest remains in the field of prison-based deradicalization programs for convicted terrorists, as well as policies of deradicalization programs outside the prison for violent extremists. He also interested in the topic of counterterrorism, transnational organized crime, criminal law and human rights, crime and justice, and crime prevention. The main research objective to develop alternative policies for the prevention of crime and violence. So, Mr. Igede Widyana Suharda, PhD, you have 30 minutes to present the material. So, please, the floor is yours.
Thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. I'm very pleased to be here, to be one of the speakers for this international conference. First of all, I would like to say thank you to my colleagues, Masahiro, PhD, and also Dr. Kwang. He flies far away from Australia and Thailand to come here to be with us in this morning for the plenary session of the second international conference on law and society. I will begin my presentation with a general perspective, which is already mentioned by Masahiro and also Dr. Kwang as well. Could you please share my PowerPoint, the operator? Yeah. I will be presenting my paper entitled Restorative Justice in Indonesia, Current Regulation and Implementation. As Dr. Kwang said, I will try to overview what happened in Indonesia regarding the implementation and also regulating restorative justice in our multicultural society. So this is my point today. I think Masahiro already mentioning about the theoretical frameworks. He did lots of work on restorative justice. And also we got many information from Dr. Kwang about the implementation of RJ in Thailand. And now my turn to explain to all the participants what happened in Indonesia regarding the restorative justice principle and implementations. Next. Yes, this is already understood by many scholars around the world, especially who have a concern about restorative justice. We have a justice paradigm shifting, and also is currently happening in Indonesia. From the oldest one, we call it retributive justice, which is offenders must be punished. So everyone will be thinking about who are the criminal, they must be punished. Who did crime must be punished and sent to the prison, kind of that thing. So we call this justice is retributive justice, and also the focus is suffering the offenders. We don't have any idea about how to rehabilitate offenders, but the point is how to suffering the offenders, because they did crime or they did bad thing and makes harm in the society and to the victim and so on. So they must be punished and they must be suffering. So that's the point for the retributive justice. And then we move to the restitutive justice, which is emphasizing fairness on compensation. So it's not just about how to, make the offenders suffering, but also how to compensate the victims of the crimes. So this is the shifting. And then the focus is on the recovery of victims' harm and loss. It's actually in Indonesia, where the victim get compensation, for example, terrorism victims. So when they, identified as terrorism victims, they can apply for a restitution for the government, and they got it. And we applied it is already in Indonesia. And then the last one, as the topic of the conference today, we then move to restorative justice, which is emphasizing justice and restoring the situation and, restoring balance in society, which already mentioned also by Masahiro and also Dr. Huang in Thailand. And then the offenders and the victims are brought together to solve the problem. So it's not just punishing, but also the victim, they join actively in solving the problem, in solving the crime. So they get agreement and then make a peaceful solution, both of the victim and the offenders. And then community members are also involved in the recovery efforts. It's not just the responsibility of the offenders and the victims, but also community members are involved in the recovery efforts, such as public figures, community leaders, religious leaders, and so on. They also have a responsibility to solve the crime that's already happened in the community. So this is the point as well, talking about restorative justice. Next. This is about the legal sources for RJ in Indonesia. RJ in Indonesia, as you maybe already understand as well as an Indonesian, as a law student, we have a Supreme Court Regulation number 2/2012 on adjustment of limits on misdemeanor and amount of fines in the penal code. This is the first regulation that produced by the government through the Supreme Court regulation. And then followed by Memorandum of Understanding between state agencies and also decree of the Director General of the General Court Agency within the Supreme Court. And then another institution also already issues regulation regarding restorative justice in Indonesia is the Attorney General's Regulation number 15/2020. So the Attorney Generals issued a regulation concerning specifically on restorative justice. And also the Indonesian National Police, they issued a regulation specifically concerning on handling of crimes based on restorative justice. This is a very important regulation in Indonesia when we're talking about RJ, restorative justice. I think law students in Indonesia already understand about these legal sources for RJ. Next. I would like also to explain a bit about a theoretical framework when we talking about restorative justice or RJ in relation with discretion. We have an idea about discretion in the implementation of criminal law. And when we're talking about discretion in relation with restorative justice, then we can say RJ is the narrow aspect of discretion, because the broad aspect of discretion, it covers all aspects of police duties. For example, when a police doing his job to, when traffic lights were on, and then they should, bring something like important people, and then they pass the traffic light without any information. This kind of discretion, this is broad discretion by the Indonesian National Police. But we can say also there is narrow discretion specifically in the criminal aspects. So when the Indonesian National Police did discretion by using restorative justice principle, we can say that this is a narrow aspect of discretion by the Indonesian National Police. This is a bit a theoretical, framework to explain between discretion on one side and RJ on the other side. Next. Legal definition. It is important to mention, as Dr. Kuang as well mentioned about uniform definition in Thailand. I think in Indonesia, we cannot find apple-to-apple definition between the institution. So as you can see, the police department, we can see at Article 1, number 3, in the police regulation, RJ is mentioning like that. And then if we then have a look to the Attorney General's regulation in Article 1, number 1, RJ is mentioning like that. But the definitions pretty much the same actually, containing the same norm and the same value, even though it's not actually apple-to-apple definition between those two regulations. And I quite interested in the phrases who put by the Attorney General when stated there, no retaliation. So this is kind of, exceptional thing for the restorative justice, where retaliation is not applied, is not allowed when solving a crime. So this is the important point from the Attorney General regulation, where it is emphasizing about there is no retaliation when solving a crime. So again, it's pretty much the same, the definition from Indonesian National Police and the Attorney General, so it's pretty much the same. The difference is just the highlight from the Attorney General regulation, where no retaliation must be applied when we're talking about crime and criminal law enforcement. Next. The point is already mentioning by Masahiro and Dr. Kwang as well. RJ is an approach in criminal law enforcement that seeks a peaceful settlement. It is not just looking to win or lose, not just to punish the offenders. So that's the point of RJ. And then the goal is to build conditions of justice and balance between offenders, victims, and society. And then the benefits of RJ, there will not be too many cases going to court. As nowadays we can see in Indonesian criminal justice system, there are many cases going to court without screening. By using this method, there will not be too many cases going to the court. There is efficiency as well as being useful to mitigate socio-political turmoil in order to maintain harmony, security, and order. So this is the point of RJ. Actually, around the world, around the globe, is pretty the same, whether maybe one country to another country, different problems when they regulate and implementing the RJ principles. Next. The rule, I think we can skip this. Yeah. Next. I would like to show to all of you the data about the number of RJs implementation by the Indonesian National Police. Quite impressed. You see the number of implementation by the Indonesian National Police were quite impressive. In 2018, there were total 1,226 cases. And then 2019, 4,250 cases. And then in 2022, 9,450 cases. And in 2021, until April 2021, there were 5,383 cases, which is quite a big number if we compare with other countries. Maybe they don't get as big as this number when they're implementing restorative justice through their criminal justice system. But how effectiveness is a big question on that. Like Masahiro mentioning, how satisfy the victims, how the implementation, like Dr. Kuang as well mentioning, is a big question. But first of all, we can be impressed by this huge number of total cases solved by the method of restorative justice. And then, next, the implementation by the prosecutors, it's also quite impressive as well. You can see in 2022, from July to July 2022, there were 275 criminal cases were solved by using RJ method. It's quite impressive as well. And hopefully this number increase in the future, and the effectiveness also can be measured. As Masahiro mentioning, the effectiveness also should be measured. It's not just the efficiency, but also the effectiveness of the implementation of restorative justice. Next. Some issues. I would like to explain some issues in the Indonesian context about RJ. The first is how to define victims in the context of restorative justice. It's a bit difficult. Currently, amongst the officers, found difficulties in defining victims in the context of RJ. The first cluster stated that limited 2% as the victims. There are scholars conclude when we are talking about the victims on the context of RJ is just limited to persons, because the law on the protection of victims and suspect stated victims as a persons. So it was not possible to implement it RJ in the context where victims are not people. For example, in the corruption, who is the victims when we're talking about corruptions? It's not people, right? The victims is a country, a state, because of the corruption. So in this context, some scholars stated that it's not possible to implement it RJ because the victims are not the people. So RJ is just in the context where victims are people. That's the first cluster when we discuss about the victims in the context of RJ. But there is also another cluster who stated that it is not limited to person. So it is also possible to apply RJ method to the victims who are not people. For example, a state, the environment could be a victim. When we're talking about environmental crime, the victim is environment. And then when we're talking about corporation, there is also a crime who committed by a corporation, and the victims at the corporations is also could be resolved by using RJ method. So that is the second cluster stated. It's not just a person when we applied RJ, but also another types of victims. And then the second issue, can RJ be used to all types of crime? This is actually related with the first issues. So theoretically, yes. Masahiro already mentioned and also maybe wrote down. I read your paper and article, very nice article. Theoretically, it could be applied to all types of crimes. Even though murder, terrorism, corruption, everything, all types of crime could be, applied, could be solved by using RJ method. This is theoretically framework, but practically no. In the Indonesian context, I say, this is from the Indonesian context because according to the regulation, the Attorney General's regulation and also the Indonesian National Police regulation, there is a limitation for some types of crimes, which is RJ are not allowed to be used. As I mentioned, terrorism, you can check on the Indonesian National Police regulation, terrorism are not allowed to be used for, RJ. Also, when we are talking about crime against life, for example, nowadays we already, got many cases, murder. Do you follow huge cases in Indonesia? Verdi Sambo. It is not possible to use restorative justice in this case because according to Indonesian National Police regulation, it's not to be allowed to use RJ when he make crimes, killing people, crime against life, so are not to be allowed to be used. So practically no. This is a big issue. This is a big concern amongst RJ practitioners and also scholars, how to solve this issue. So we cannot be, conclude today in conference, but I must deliver. This is the second issues when we're talking about restorative justice. And then the last issues from the Indonesian context is how strong the police regulation and Attorney General's regulation as the legal sources of RJ in Indonesia. Because, the highest law for the implementation of, law enforcement is the law as well. So we call it in Bahasa Indonesia undang-undang. Undang-undang is higher than regulation. Attorney General's regulation and also Indonesian National Police regulation. So the problem is the law of criminal procedure, or we call it KUHAP, higher than Attorney General's regulation and also Indonesian National Police regulation. The issue is in the law, there is no room for provide RJ. That is the issue. So there is a conflict norm between Indonesian National Police regulation and Attorney General's regulation with KUHAP, the law of criminal procedure. So what's going on next? This is the big question in the future. But as we can see, the implementation is going on, implemented by the Indonesian National Police and also implemented by the Attorney General. You see the number, meaning that RJ has been implemented by the Indonesian government. But this is still also can be raised as an issue when we're talking about RJ in the Indonesian context. Next. This is the conclusion, maybe. Wait a second. This is the conclusion. Okay. I would like to conclude my presentation by deliver 2 points. The first is RJ is a mission or a philosophical framework, which is still, developing. And then RJ is a different ways to respond to crime in the society and the criminal justice system. I do believe every society, has their own method to solve the crime and also try to make a peaceful society. And this is one important conclusion that RJ in the society, so different society has another types to respond crime and also social problem in the society. I think that's all from my presentation today. Thank you very much, and we can discuss later on. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr. Gede, for your information about RG in Indonesia and from theoretical and implementation. So, in this session, ladies and gentlemen, now come to the question and answer session. We have 15 minutes, 15 minutes for Q&A. I like to have 2 questions from the participants, from lecturer, student, and other participants. Please, your raise hand if you have any question for 3 speakers, for Mr. Masahiro, for Mr. Dukwangli, for Mr. Gede. Yeah. Please, Miss, call your name and from
Assalamualaikum warahmatullahi wabarakatuh. Thanks to the moderator for giving time to us. Before that, let me introduce myself. My name is Nancy Indira Sukma. I'm a new student at the Faculty of Law, University of Jember. This question is for Dr. Masahiro Suzuki, PhD. If there is a case and the case can be resolved with RG, but one of the parties does not want to admit their mistake, even though they are forced to admit it many times, then how do you solve this problem with RG in Australia? As we know, one of the conditions for settlement of RG is that the perpetrator of the crime must admit his guilt. And second question, as we know, of course, there are also many other obstacles in implementing RG in Australia. Then, how do you overcome this obstacle in the future? Thank you.
Please, Mr. Masahiro, answer.
Thank you for your question. As in response to the first question, so in Australia, to participate in RJ, offenders have to admit their offense. They already have finished the guilty plea. So in that sense, offenders have there's some degree of acknowledgement of offending, because that's one of the requirement to participate in restorative justice program in Australia. But in some cases, there's complication to it, because, for example, if the case is the fighting between 2 young kids, victims may actually be the offender who provoked the fighting. So in that case, offenders may partially or fully deny the responsibility during the course of discussions over what has happened. But basically, in response to your question, admitting guilt is one of the requirements to participate in restorative justice in Australia. I couldn't quite catch the second question. Can you please repeat the second one?
The second question is, as we know, of course, there are also many other obstacles in implementing RG in Australia. Then how do you overcome this obstacle in the future? Thank you.
So you mean, yeah. Well, I believe that's the issue of what we call the institutionalization. So as Dr. Gay and Dr. Kwan mentioned, there's pros and cons of RJ being situated in the criminal justice system. One of them is one of the benefits of having restorative justice program as an official program within the criminal justice system is to easily get funding because that's national program or government-led program. So it's legislated, so it's easy to get the funding and it's easy to expand because it's a government program. But on the other hand, this institutionalization, being RJ, situating RJ within the criminal justice system, has repercussions over the concept of restorative justice because, as other presenters mentioned, the aim of retributive criminal justice system is different from restorative justice, and so there might be some compromise over the implementation of restorative justice in the sense that we may have to prioritize the aims and goals of criminal justice system in the restorative justice program. For example, one of the aims of criminal justice system is to rehabilitate offenders. So restorative justice, instead of caring for victims, may become offender-centered. They're gonna talk about a lot about offenders instead of victims, how victims are impacted. Well, your question is really big, so to be honest, I don't have answer for that here. But yeah, so there's always compromise. I mean, there's always compromises in any justice practices. So I think it's our job to find a solution to that. So let me solve that problem in the future.
Okay. It's enough, Mr. Masahiro? Yeah. The second question from participant. Okay, I choose a man, yeah. Raise your hand and introduce yourself. It works?
All right. First, introduce myself. My name is Wikan. I'm a student from Faculty of Law in University of Jember. So, I have a question for Mr. Gede about RG in Indonesia. Why in Indonesia there are difference in the treatment of RG settlements of between the police, the prosecutor, and the court, where the settlement of RG in police is enough with a piece of piece paper, and it is enough to be decided by an official at the echelon 4 level, like a Kasat or Kapolsek. While at the Attorney General office, it must be decided by an official at the echelon 1 level, thus creating a gap or difference that is a quite large, which has the potential to lead to unprofessional handling of case. So it also gives the impression of the taking over of the authority of the court judge in deciding whether the per- perpetrator of a crime is guilty or not, and in the terms of sentencing relate to the theory of dominus litis. Thanks.
Okay, thank you for the question. I cannot get the second question. I just get the first question. I try to explain to you that RG in Indonesia is is a new paradigm as well. As I saw the shifting about the justice paradigm, because it's a new paradigm. So the institutions, the law enforcement officers define RG in the different ways. So that's why, as you mentioned, the Indonesian National Police and also the Attorney General apply different method when they use restorative justice in solving a crime. And the problem is, I mentioned already in my presentation, our KUHAP, the law of criminal procedure, didn't regulate about restorative justice. This is the problem. So that's why the institution and then issued sectoral regulations. So that's why also there is difference between the police, the attorney generals, and also the court. So that's the problem. And that's why I also mentioned in the public seminar as well, in the future, in our KUHAP, it should be regulate about this kind of method. This kind of thing should be regulated in the KUHAP, so everyone will get the same perception about how to apply restorative justice in Indonesia in order to, solving a crime. That's the problem. So that's also the solution in the future. We need to revise KUHAP and put restorative justice in the KUHAP. So there is no sectoral regulation, which is, they try to regulate their own perspective and own method when they applied RJ. Even though I think in the internal institution as well, they still didn't get the same point about how to apply it. Between one police to other police, maybe have different opinion. Between one prosecutors and others also maybe have different opinions in implementing RJ. So that's the problem we face today in Indonesia, but don't worry, we will solve the problem. And I have a discussion with Masa, it's not just in Indonesia, everywhere around the world is still struggling with how to implement and how to regulate restorative justice in the community. I think that's the question, and maybe for the second question, I don't really clear about your question, but I think it also covers your problem in the second question. Thank you very much.
Thank you, Mr. Gede. One question again. Yeah. Please introduce yourself.
Thank you for the time. Let me introduce myself. My name is Deborah Milani Syahaan. I'm from Faculty of Law, University of Jember. Okay, my question for Mr. Igede Widiana Swarda, PhD. What's your opinion about the use of restorative justice for minors as perpetrators of criminal crimes? For example, what went viral some time ago was a senior high school student who abused a grandmother who had a mental disorder in South Tapanuli. Why are cases like this often left alone just because the perpetrators are underage? Even though Indonesia also has laws for underage criminals, I think it's unfair to the victim. Thank you.
Okay, Deborah, thank you for raising the question. I also faces the same question in Papua when I mentioning about new penal code, the draft of new penal code, when some participants stated that, disagreement to use RJ when we're talking about crime because of the victim perspective is unfair for the victim. So they said they must be sent to prisons. Whatever the situation, even though Indonesia has no many prisons, overcrowded, it doesn't matter. Let's build another prisons, no matter with RJ. So the problem is, how come victims get justice if every case is solved through RG? I said that, the paradigm, even though there was a shifting, the retributive justice is also still applied. As I mentioned as well, theoretically, yes, applied to all types of crime, but practically no. Because some types of crimes are not allowed to be solved by using RG principles. Terrorism and then crime against lives are not allowed to use, RG to solve the crimes. And the most important thing I would like to say is, we cannot conclude that criminal law is much softer, becomes softer and softer. That's the conclusion from the public when I talk about RG in Papua. I said it is not the same as the meaning of, criminal law becomes softer and softer. In some cases, we still use retributive justice, but in another case, we also must apply and give a room for restorative justice. If not, we will find nenek minah cases in the future because there is no room for RJ. So that's the problem. And we can make an analogy. If everyone, get cough, flu, and then should be sent to the hospital, does it efficient? Is it effective? I think it's not effective, right? It's not efficient as well because just flu and then coughing should be sent to the hospital. It's pretty much the same when just misdemeanor or minor criminals and then sent to the prison, sent to the jails. What happened? Overcrowding, and maybe they gonna learn about crime by another criminals in the prison, and then when they went out from the prison, they become more high criminals, more high class criminals. Similar, when we send people who just get cough and flu to the hospital, when they went out from the hospital, they got many diseases because get affected by another patient in the hospital, kind of that thing. But I do agree as well as you, when we applied RG, we should think about the justice for the victims. As Masahiro also mentioned, how effective RG, how satisfied and then the victims with the RG. If not, and then the cases must be sent to the court and then punished by the judges. I think that's the point, Deborah. Thank you for raising the question. Thank you very much.
Okay. But your opinion, Mr. Duke, about the question? Yeah. If there are any question for Mr. Duak Kwangli? Okay. Yeah. Please introduce yourself. The last question, yeah, because the limited time. Mr. Duak Kwangli, yeah, for Mr. Duak Kwangli.
Thank you. First, let me introduce my name. My name is Eji Daniel Syadi. I'm from the Faculty of Law, University of Jember. I want to ask the three questions. I would like more explanation about forgiveness. How much space do victims have in is restorative justice mechanism in Indonesia, Thailand, and Australia? My second question, to what extent can the victim apology affect the criminal process carried out by law enforcement?
You can explain your question with Bahasa Indonesia.
Oke. Pertanyaan pertama, seberapa besar ruang yang dimiliki korban dalam mekanisme keadilan restoratif baik di Indonesia, Thailand maupun Australia? Pertanyaan yang kedua, sejauh mana permintaan maaf korban dapat mempengaruhi proses pidana yang dilakukan oleh penegak hukum?
Thank you.
Yeah, thank you very much. As far as I understood, the question is what role or what space we should grant to the victim in the RJ processes. And to my understanding is that the RJ concept is based on the focus on the victim. So basically, I would say the more the merrier, the bigger the better. The only thing I would like to highlight or to mention here is that, of course, the victim enjoys this special position, but we have also to take care of the position of the offender in this dialogue, in this conference. And so the same thing that applies to the offender, should also apply to the victim. So not concretely, not to pressure the offender, or the offender does not pressure the victim, and all these kinds. So basically, yes, the utmost space for the victim, but same rules for both sides in terms of the right to express their feelings, the right to express their interest, and not to pressure the other side, especially when it comes to trying to engage the offender into things like self-condemnation, acknowledging the guilt, to be able to self-forgive oneself. That is even then more important. This was my first approach to your question.
In terms of the application of restorative justice for victims in Australia, well, I must say it differs between states. So unlike Indonesia, Australia is a federal country, so there are 6 or 7 states. I forgot, but I'm bothered to count. Yeah, it's expanding. So some states even use restorative justice for sexual violence, or like rape, sibling incest. But other states also uses restorative justice to mediate the family violence, domestic violence. So it differs between states, but essentially, restorative justice used for almost all types of crimes, as long as victims are willing to participate in restorative justice process.
One more question. Yeah, the last question. Yeah. Please introduce yourself.
Okay, thank you. First of all, I will introduce myself. My name is Davina, and I'm from Faculty of Law, Jember University. This is my first time hearing about restorative justice. And the things I'd like to ask to all speakers is,
We all know, as already stated, that RG process based off self-forgiveness. Rather than solving the problem with RG will guarantee justice for all parties. I mean, in Indonesia, we say menjamin keadilannya. Or is it only the first step before entering the judiciary? Or in Indonesia, I mean, is memasuki peradilannya. And then if the justice will guaranteed by RG, what kind of justice that will be accepted by all parties? Thank you.
I understand the first part of your question is that if RJ can be a first step of the conventional criminal justice process. Is that correct? Yeah. Okay, there are basically the RJ is claiming per se to be an alternative to the conventional criminal justice process, because it claims to be faster, to be more justice, to be superior, because it's not resting, as said, on redistribution, but on victim protection in meeting the needs of the victim. So it's an alternative. It's another way. It's another channel besides the conventional criminal justice. And I personally think there are many reasons to go this way. But also, as Dr. Gede spoke about, there are, I think, limits on certain crimes to which RJ can be applied or should apply. But this is very difficult because, as he also said, there are people, proponents of RJ, they say you can apply RJ to any crime, murder and so on, and sexual assaults and so on. They even argue that in these serious crimes, even there, it is more rewarding or more efficient for the whole process if the offender, for example, confirms his guilt because of this weight of the crime. I personally think that's maybe to be carefully observed, considered, because in terms of these serious crimes, there are much more factors considered about the family members of the victim of a rape, of a murder. What about the community? Yeah, what a community, the values of the community. All these have to play in at the complete cultural context of how to deal with rape or crimes against crime. This is a very contextualized question, and for India it might be answered differently as for Thailand, and even for Thailand you have difficult, because we have the Muslim majority in the south part of Thailand. They might answer this question differently from a more Buddhist part of Thailand. I hope I answered your question.
All right, thank you for raising the questions. Is about how to measure actually RG in terms of solving the crime. The key word, in my opinion, is satisfaction. Agreement without pressure between the offenders and the victims. When we can reach this agreement, we can say that, or we can conclude that RG is effective. So the agreement between both parties are important, even though the families of the victims and the families of the offenders as well should get involved in solving the crime. So that's the keyword for your questions, where the victim give forgiveness for the offenders, and also the offenders as well recognize the wrongdoing that he did, and then the agreement between both parties are reached. So that's the point. That's the point. Agreement without pressure and then satisfaction between the parties. So we can conclude RJ is successful. Whether, Masahiro also questioning, is that effective? So that's another question. But as long as, once again, satisfaction are reached, that's the successful point of restorative justice. I think that's my question. Thank you very much.
Okay, so I'm gonna answer how justice can be guaranteed through restorative justice. I think that's your question, right? So, well, to be honest, it depends on the context. So, what kind of offense is it? So, for example, offenders damage the mailbox at your house. You may just want the offenders to fix it. Or if the offender damages your car and you have to spend money to repair the damage to your car, you may just want compensation from the offender. Or if it is interpersonal violence, or for example, you may be punched by the offender, you may just want an apology letter or just verbal apology from the offender. So restorative justice has that mechanism to satisfy victims' needs, because restorative justice, as I mentioned during my presentation, is a process. So dialogue-driven process. So it normally has two phases. The first phase is a storytelling phase. So it normally starts with offenders explaining the situation where the offense had happened. And then other participants ask questions to the offender about, for example, how did the offender feel when they engaged in offending and so on. And then next button is delivered to the next participant, are normally victims. Then victims explain how they are impacted by the crime. And then other participant, it may be victim supporter, family member, or police officer, and so on. They all talk about how they feel about offense, about what had happened. So that's the storytelling phase. So once they agree, they reach consensus over what had happened, then the restorative justice moved to the next phase, which is called agreement phase, agreement discussion phase. So in this phase, participants are going to talk about what should be done to repair the harm caused by crime. So what offenders should do to make amends to the victims. So they can all talk about, okay, so offender should do it. Or offender may themselves say, I think I should do this to show the remorse to the victim and so on. So here, in that phase, victims can raise their voice as to what they want from the offender, what they want from the community and so on. Then they make what is called agreement plan. So normally it includes the victim's demand, compensation or apology letter. So that's how the restorative justice process can guarantee the justice, to deliver the justice for the victims.
Okay, because this is the last question, and then, ladies and gentlemen, we finally come to the end of this international conference. Before I close the international conference, I would like to take the conclusion from what the speaker has presented, from Q&A also. The legal framework RG among Australia, Thailand, and Indonesia, and the implementation of RG, I mean that RG is one model to achieve justice and benefits to society. Yeah. So I would like to thank you for the speaker for the informative and interesting presentation, and all the participants for the very active participation. Finally, I give the applause for the speakers and for you all. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Namo Buddhaya. Salam kebajikan, salam rahayu.
Thank you very much to all speakers that already gave some introduction materials to the participants. Before we continue to the next agenda, we are pleased to inform you that we have 1 hour break session. So, all of you should be ready at 1 o'clock to rejoin again for the panel session. To the panel session, we have to inform that the panel session will be followed by the presenters and going to lead by moderator from each room. For panel 1, Criminal Law and Criminal Policy in Muhammad Ali's room. Panel 2, Human Rights in Samsi Kusairi's room. Panel 3, Economic and Social Impact in Bastian's room. For panel 4, we have Law Enforcement and Suwondo's room. For panel 5, Politics of Law and Public Accountability in Kopong's room.
Terima kasih kepada para presenter. Terima kasih kepada para tamu undangan yang telah memberikan materi pada saat plenary session. Sebelum beranjak pada sesi berikutnya, Bapak Ibu sekalian memiliki waktu 1 jam untuk sesi istirahat hingga pukul 13. Oleh karena itu, ketika sesi istirahat berakhir, para presenter diharap masuk kembali ke ruangan masing panel yang telah ditentukan. Sebagaimana ruang panel 1, Criminal Law and Criminal Policy di ruang Muhammad Ali. Panel 2, Human Right di ruangan Samsi Kusairi. Panel 3, Economic and Social Impact di ruangan Bastian. Panel 4, Law Enforcement di ruangan Suwondo. Dan panel 5, Politics of Law and Public Accountability di ruangan Kopong. Untuk para partisipan dapat masuk sesuai ruangan yang nantinya akan sesuai dengan minat masing-masing dari partisipan. Dan ketika sudah selesai, kepada para presenter maupun partisipan dapat kembali bergabung di ruangan ini untuk melakukan sesi penutupan. Selamat istirahat dan menikmati sesi diskusi di masing-masing panel dan harap tepat waktu. Terima kasih.